Yes, Mr. Kelly.
My lady, my lords, good afternoon. The respondent's overall submission is that the Upper Tribunal's conclusions in this case were concordant with the statutory regime, its purpose, its context, and disclosed no error of law. By way of introduction, I wish to set out briefly some important contextual points which frame the submissions which will follow. Local authorities have the power to make decisions in respect of children with special educational needs that have lifelong consequences for those children and their families. And there is, therefore, a substantial inequality of power between, on the one hand, those children and those families, and on the other, the local authorities. The purpose of the statutory scheme we're dealing with today, the Children and Families Act 2014, is of course to support and protect the interests of those vulnerable children, but it is also to provide children, young people and parents with greater control over the decisions that are made by the local authority and to involve those people in those decisions made in respect of special educational needs provision. And the Act does so in three particular ways. First, in my submission, it makes the views and wishes of the children and their parents of central importance and central to decisions made by the local authority. Second, throughout the Act, there is an emphasis on continuity in special educational needs provision where that provision is required. And third, the Act provides what I submit is an accessible safeguard against faulty local authority decision-making in the form of a costs-neutral, informal, specialist tribunal, which can consider challenges against decisions which have the most significant consequences for children. Those are, of course, the decisions about whether to provide special educational needs at all, the content of the plan that is put in place, and the decision whether to withdraw that provision. That, I submit, as an important context to the Act and the grounds of appeal before the court. And with that in mind, I propose simply to respond to each ground in order. I will provide you, my lady, my lords, with a roadmap in respect of each ground as I turn to it. So, turning to ground one first then, our submission overall here is that the Upper Tribunal correctly delineated the jurisdiction of the First-tier Tribunal, and it was correct to find that the ceasing decision in issue here, which was made in flagrant breach of Regulation 31 of the SEND regulations, could not stand. And I'm going to develop that overall submission by making three subsidiary decisions before dealing with some cases that my learned friend relies on. So I will just outline those three submissions now, if I may, and then I will go into them in more detail. The first submission is this. The mandatory provisions of Regulation 31, which require consultation with the child's parents, and the head teacher of the school, go to the heart of the effectiveness of a ceasing decision and a decision to stop providing special educational needs. And the right of a child and his parents to be consulted and to be part of the decision-making is central to the statutory scheme.
To the statutory what?
Scheme.
Scheme.
Yes.
Thank you.
The second submission is this. There is a strong presumption, therefore, that children and their parents should be able to vindicate the rights that they have under the regulations in the forum that Parliament created to challenge ceasing provisions. that is the First-tier Tribunal. And there are no words in Section 51 or elsewhere in the Children and Families Act, in my submission, which are capable of displacing that strong presumption. The third submission is that the First-tier Tribunal's Section 51 jurisdiction is broad, and it can consider all aspects of a matter, so long as that matter falls within the gateway provisions of Section 51.2. I accept the Tribunal has a general appeal jurisdiction, which permits it to stand in the shoes of local authorities and act inquisitorially when necessary. In my submission, it also has a supervisory jurisdiction to apply the law in this area and to review decisions that are manifestly in breach of the law. So turning to the first of those submissions, the process of consulting the child and involving them in ceasing decisions particularly, but indeed in other decisions in the Act, is a necessary element of correct decision-making by a local authority. I rely and wish to associate my case with what has been stated by my Lord Justice Stuart-Smith in the Milburn case. Now, it might be, my lords, my lady, that it's not necessary for me to revisit that.
As I said this morning,
yes.
Lord Justice Stuart-Smith no doubt
Indeed.
calls it vividly, but
I propose to take you to it.
my lady and I were not there.
So it's behind tab 22 of the authorities bundle, and it starts at page 412.
Yes.
By way of a brief reminder of the facts of this case, this was a case where a decision had been made without consultation, and there was no consultation, and the parents complained to the FTT, First-tier Tribunal, about that. They also complained and put a complaint into the Ombudsman, and essentially the Ombudsman decided that it could not deal with the question of consultation, or the failure to consult, because that was part and parcel of the matter under appeal in the First-tier Tribunal. So if I could take the court to page 428 in particular, please, to paragraph 45.
Sorry, before we go there, can you just give me a moment to read the head note?
Of course, my lord.
Right, sorry, 45.
Paragraph 45, please, my lord. 428 is the page. Perhaps if I could just ask the court to consider that paragraph. It goes over the page onto the top of 429.
Yes.
I'm grateful. In my respectful submission, my Lord, Lord Justice Stuart-Smith, sets out entirely rightly the importance of consultation in the statutory scheme. It is an essential element to local authority decision making. I submit the position is one step further than that, and that consulting and obtaining information from children, young people, their parents, when making a ceasing decision in particular, is integral and part and parcel of the safeguards that bound the local authority's decision making. It is built into the very structure of an effective decision, and it is essential to it. And in support of that submission, my lady, my lords, I wish briefly to take you to the statutory provisions themselves, to two of them.
I said that over lunch I would look up the cases from an AG onwards, Sen AG onwards, at some moment which is convenient. I have looked them up, and I'll give you details as and when anybody wants them.
I'm very grateful. I will turn to Sen AG, and I will take that opportunity very gratefully. Thank you, my lord. Could I ask the court to turn, so behind tab 3 to section 45, first of all, which is on page 27 of the authorities bundle.
Sorry, tab 3, page
27, my lady. And in particular, may I ask, my lady, my lords, you to look at subsection 4. So this is subsection that asserts the prohibition against ceasing to maintain a plan until the end of the period allowed for bringing an appeal against that decision. And of course, the prohibition stays in place if appeal is in fact brought. Then over the page at subsection 5, regulations may make provision about ceasing to maintain the plan, including at C, in particular about the procedure to be followed. This, in my submission, is what, in the words of my lord, creates a supplemental provision in the regulations to this statutory section, section 45. So with that in mind, could I ask, my lady, my lords, could I ask you to turn to regulation 31, which is behind tab 7 at page 64. The first point we make about regulation 31 is in respect of subsection 1. The plain words of subsection 1 in my submission suggest that consultation is or should be part of the local authority's consideration of the question whether to cease to maintain. That is why it is set out in the terms such as it is, where a local authority is considering ceasing to maintain, it must, so on and so forth. So consultation is therefore a necessary element to a correct exercise of judgment by the local authority in respect of a ceasing decision. The second point I submit is this, and it is necessary to start at the end of regulation 31 this time. We have seen the prohibition against ceasing that applies in section 31. Now, the clock starts to count down to the expiry of that prohibition against ceasing on, from the date of notice. Because the date of notice is the time for which limitation for an appeal starts to run under the relevant rules of the tribunal, of the First-tier Tribunal Health and Social Care Chamber. And so what regulation 31.3 does is require a local authority in its notice, first of all, to inform parents of their right to appeal and the time limits, because the clock will be ticking after the notice is sent. And if we look at subsection 2, it is cast in the following way. Following the consultation that the local authority determines cease to maintain, it must notify. That means in my submission that consultation is not only built into the consideration that's required, it is also the building block on which this safeguard is erected. There has to be a precedent consultation. On the basis of that and following that, notification to cease to maintain can be sent, and that starts the clock ticking down to the prohibition being lifted on ceasing to maintain the plan.
But if you appeal, then regulations maintain the plan until the appeal is determined.
Yes, that's right.
If there's a waiting time of a few months, that's the authority's problem.
That may be the authority's problem. And of course, that is why it's so important, and from a practical perspective, for the parents to be informed of the time limit and to appeal and the right to do so, which of course didn't happen. So that, in my submission, is a safeguard that preserves an appropriate balance of power determined by Parliament between the parents and the child and the local authority in this area, which has significant consequences otherwise, or indeed anyway, for the child's long-term development. And that is why, in my submission, looking through a Synergy lens, if I can come on to Synergy, my lady, my lords, we submit that Parliament did intend invalidity of a ceasing decision if it's made in plain breach of Regulation 31. Regulation 31 isn't just any procedural obligation, it is tied into the safeguards in Section 45 itself. Now, I'm conscious I don't want to embark further without having the opportunity, if necessary.
I was part of a court that looked at this in, as long ago as September 2025, EWCA Civ 1174, paragraphs 25 and 46 to 48. The case is almost unpronounceable, but it's Fatolazadeh, Fatolahzadeh against the London Borough of Barnet. In that passage, I referred to Synergy, AI Properties, which was mentioned this morning, Leyden, which is 2025 UK Supreme Court 12 at paragraphs 76 to 77, and at the Court of Appeal, decision of Sir Terence Etherton as Chancellor in Nat against Osman 2014 EWCA Civ 1520 at 24 to 34. As the names suggest, certainly Nat and Osman is a land property case, so they're not directly, in that respect, they're not directly in point, but all those cases are looking at Synergy and, first of all, emphasising that it's a matter of statutory interpretation, and then looking at what the court should look at.
Yes, and I wouldn't disagree or seek to resile from any of those principles.
It's just that since at least one of the members of this court has got it in mind, you need to know.
Yes, I'm very grateful.
What you do about it is entirely up to you.
I'm very grateful. Thank you. But in any event, we say that looking through a Synergy land, we can fairly construe this as indicating total invalidity, especially taking into account the context that I framed my submissions with at the start. And so, in my submission, the Upper Tribunal was right to conclude as it did. I wish at this point, and I'll come on to this in more detail in a moment, just to assert a secondary alternative submission in the case that my lady, my lords, are not with me about total invalidity. My alternative submission is this. Because Regulation 31's consultation is central and integral to a proper exercise of judgment, when the First-tier Tribunal is looking, as I think it's agreed it may, at whether a decision is correct, not only in fact in law, but also in judgment, the fact that Regulation 31 has not been complied with at all will be determinative in this sense that the judgment of the local authority cannot possibly be correct if it's proceeded on the basis of completely ignoring and not obtaining any of the views, not only of the child but also of the school. And that, of course, is what happened in this case. A local authority, in my submission, must be bound when exercising a decision with the potentially great effects that the ceasing decision has, to have regard to the situation in the round, looking, of course, not only at the wishes of the child, but also at the experience they have in the school and the school's view as to what's worked, what hasn't. That simply didn't happen here. And I will go on to deal with that in more detail in ground 3, but I just like it now as an alternative proposition. My lords, can I move to my second area of submissions under this ground then, which is the presumption that I have indicated. That is, that if parents have a right to be consulted and involved, as we submit they do, then there is a strong presumption that Parliament intended that they should be able to vindicate those rights in the form that it's created to litigate a ceasing decision, which is the First-tier Tribunal. Oh, I rely on the one on case of Boddington for that proposition. If I could just ask the court to turn to that, it's behind tab 10. Now, of course, it will be recalled that Boddington concerned a rather different circumstance, which was a man convicted of smoking on trains.
Yeah.
But the question was, essentially, whether or not he had a right to raise in his criminal defence the vires of the decision and the bylaws on which the decision was made, under which he was charged. I accept at once, as I must, that's a very different set of facts. But nevertheless, I still rely on this, on the principle that I'll take you to in 1 second, by analogy, because this case concerns the exercise of discretion by a public executive body in respect of an individual in a way that has potentially serious significances for that individual. Now, the principle that I rely on in particular is in the opinion of Lord Irving, which is at page 134. As I say, I entirely appreciate one has to take the case in the round and you can't just extrapolate the principles that you like, but this is a basic proposition that I rely on. And it's set out at the second paragraph on that page. If I could just...
What page are you on?
134, my lord, behind tab 10.
Thank you.
If I, perhaps rather than reading it out, ask...
This is the Pick's granite principle, as hasn't changed since I studied law a long time ago. Yes. Right. You don't particularly need Mr. Boddington and his smoking on Southern Railway to get you there.
No.
Yeah.
Well, we submit it's a basic proposition, and I rely on it by analogy.
I'm not sure there's anything between you as things have turned out. Mr. Lyon said that the FTT can consider everything when the case comes to it. He doesn't agree with you that a procedural flaw is enough to that the FTT is entitled to say failure to consult, that's it, we don't have to look at the merits at all. But he does accept that the FTT can look at the whole case. So why do you need the Pix Granite principle, Waddington?
Well, we asserted primarily in response to the submission that, and the suggestion that perhaps has fallen by the wayside somewhat this morning, that a person who wishes to seek to challenge a breach of the regulations should bring a claim in judicial review.
Yes.
And we say simply, judicial review is not a straitjacket you have to don to assert your rights. If there's a forum which Parliament has said you can assert them in, that's essentially the principle.
Yes.
And why we rely on Boddington. With that indication in mind, perhaps I can turn to the third area of my submissions then under this ground, which concerns the question of the breadth of the tribunal's jurisdiction. We submit that the jurisdiction is broad. It includes a supervisory role as well as an inquisitorial jurisdiction standing in the shoes of the local authority. And I should say at the outset, my submission is that where just a tribunal may say a ceasing decision, as was the case here, is invalid, it's made in plain breach, it cannot possibly be right, it must be set aside. That does not mean, of course, that the tribunal stops there. The tribunal then has to decide what should happen with the child's special educational needs provision. And it can go on, of course, after that to look at the merits and say, well, either actually, as it happens, we agree in the circumstances, the plan should be ceased to be maintained, or it should be maintained with amendments, or we're ordering you, local authority, to maintain the plan. It is, I don't think I need to take you to it as a simple proposition, but as a matter of construction, the jurisdiction in section 51 is broadly drawn. A parent may appeal against the matters to the tribunal, and then the matters are set out as gateways in subsection 51.2. The supervisory jurisdiction was recognised under the antecedent regime, in particular by Lord Justice Sedley, and we rely on a statement from Lord Justice Sedley in the case of Hounslow, and I think we may have been taken to this already this morning. It's at page 232 of the authorities bundle, behind tab 14. And it's at paragraph 32. So this is Lord Justice Parker essentially endorsing the propositions of Lord Justice Sedley in the Bromley case. And as one sees in the second half of that paragraph, that there's a sentence at the end of the line that starts, in particular where a court has to limit itself to the interpretation of terms of legal art and setting the outer limits of the meaning that the tribunal doesn't have to.
Can I mention one? My
Yes.
hearing's not terribly good. If you could crank up the volume one
Yes,
degree,
of course,
I'd
my
be
lord.
very grateful.
Yes. So here, what is said is, for many purposes, the tribunal stands in the local authority's shoes, re-evaluating the available information in order, if necessary, to recast the statement. But in carrying out this function, it also has a supervisory role to interpret and apply the relevant law. So it's not the case in my submission that the only function or the only permissible function of the First-tier Tribunal is to recast the statement, stand in the local authority's shoes, and so on. Of course it can do that, and in many circumstances that is all in practice it will be doing. For example, if it is looking at what the content of a plan should be when there is a disagreement. But in my submission it also has a supervisory role to apply the statutory regime that's been set out by Parliament in the context of a specialist jurisdiction. And It is notable that also in Milburn, if I can remind my lords, my lady of Milburn once again, if I could ask you to turn up that case once more. So it's tab 22, but in particular this time page 430. My Lord Justice Stewart undertook a review of the statutory provisions in the preceding paragraphs, including the Send Tribunal's own rules and its powers under those rules. And I rely on the statement at the end of the top paragraph on page 430. In summary, the provisions establish a comprehensive framework for resolution of all aspects of and ancillary to the matters that may be subject to an appeal pursuant to section 51. And in my respectful submission, that is entirely correct, of course. The jurisdiction is a broad one. The tribunal, where just and necessary, may, in my submission, consider a decision to cease to maintain through the lens that it's just simply wrong and can't stand. And in my submission, what the First-tier Tribunal did in this case, I appreciate the reasoning is sparse. That is not unusual in cases of this nature in the First-tier Tribunal. But what it did in my submission was, yes, it applied the law. It said this decision can't possibly stand. It's just been taken by the local authority unilaterally without any consultation. But it then did go on to look at merits. It engaged with the disadvantage that ceasing to maintain would cause T, in contrast to children who weren't children of service personnel. And it then exercised its power in section 43 of the Send Regs to order the local authority to continue to maintain the plan. And so in my submission, what the tribunal was doing here was entirely within the bounds of its jurisdiction. Turning then finally on this ground to deal with two of the appellant's authorities. One I can deal with quite quickly. I don't think I need to take you to it. It hasn't been referred to this morning, though it is referred to in my learned friend's skeleton argument. It's the case of Calvin and Carr, which is the decision of the Privy Council in respect of the Australian Jockey Club and the Australian Jockey Club's rules. That is, for your note, my lady, my lords, that is, I think it starts at 90C. That was a case that concerned essentially the rules of a domestic organisation. The rules were founded in contract, and what had happened was a person had been suspended from membership for running a horse, and they'd been suspended for a year, and they appealed to the appeal body, which upheld the appeal, and then they complained that because there'd been want of natural justice in the original decision, that couldn't be cured on appeal. And indeed, they even went so far as to say there is no valid decision that can be appealed. Now, the Privy Council said, no, there is a valid decision that can be appealed. It's whatever else might happen to it, it's valid, sufficiently valid to be appealed. And in Calvin, the Privy Council expressly said there is no automatic or general rule that an appeal cures previous defects. It all depends on the facts. So I raise that because, of course, that is not authority for the proposition in my submission that a de novo hearing in the tribunal must then necessarily cure all procedural breaches that have occurred beforehand. But equally, it's entirely different on the facts. We're not dealing with the situation where two parties enter into a bargain, being the contractual rules of an unincorporated association, and choose to do so. We're talking about a statutory regime which applies rights and obligations irrespective of what people want or think should happen. The next case is the Hampshire County Council case. And we were taken to this morning, but if I may just return to it very briefly, it's behind tab 23, my lords, my lady.
Page.
Page 439.
Thank you.
Far from this decision being inconsistent with the Upper Tribunal's decision, we say it is entirely consistent. What happened in the Hertfordshire case was that there was a decision by a local authority not to secure a needs assessment. That, of course, is a decision that falls in one of the gateways in section 51.2. And the parents appealed to the First-tier Tribunal against that decision, and the appeal was conceded, and the local authority decided to undertake a needs assessment, to secure a needs assessment. But it thereafter did not comply with the timescale set out in the regulations to complete that assessment. That is why, if one looks at page 448, paragraphs 32 to 33, the High Court rightly determined that the question of the breach of the regulations in respect to the time limit could not be determined in the First-tier Tribunal because it wasn't a decision falling within section 51.2. The decision had already been taken in the parents' favour, and that's why it was only challengeable on judicial review. What, in my submission, this case is not authority for is the proposition that one can only challenge regulations or breaches of regulations in the High Court on judicial review. That's plainly not the case in my submission. And in fact, it demonstrates, in my submission, the distinction we make. The tribunal's jurisdiction is demarcated by the type of matter that is challenged, not by the type of illegality that's asserted. And so when my learned friend submits that the Upper Tribunal's judgment opens a door which did not previously exist, in my submission, that's not right. The Upper Tribunal was acting within its jurisdiction and correctly identified and delineated its jurisdiction. And I would finally make this point, that I do not for a moment submit that the First-tier Tribunal can look at any procedural breach of the regulations and make determinations on that. That's plainly not the case. It can only do so where those regulations govern a matter listed in section 51.2 of the Act. That is precisely why it could not, for example, consider the question of a failure to secure a needs assessment in time, because that's not a procedural breach that goes to a matter in section 51.2.
Well, the tribunal only has jurisdiction to hear appeals against decisions.
Yes.
Not doing something on time is not a decision.
That's entirely right, my lord. And so it's only where a regulation effectively governs the decision and the decision-making process, which we say it does in this case, for a ceasing decision, Regulation 31, but I entirely accept that a parent couldn't simply lodge an appeal against a failure to comply with a time limit, for example, in the first-tier tribunal, and that they would have to go and do so by judicial review if they wish to.
And elementary, isn't it? Tribunals only have the jurisdiction statute or the regulations under the statute confer on them, nothing more.
Precisely, and that was the point that was being made in Hertfordshire, rightly. If I may then, I move on to ground 2, unless I may be told I've missed something.
Could you just hold on a second? Thank you.
2 points before I do move on to ground 2. The first is that my learned friend makes a submission that a de novo appeal removes any disadvantage in the local authority failing to comply with Regulation 31, because the local authority can simply determine the matter afresh on the merits, essentially. In my submission, that has an unpalatable consequence, because essentially what it means is a local authority doesn't really have to comply with the provisions of Regulation 31, because no one's really going to enforce it. It's not practical to say that people can go and seek redress in the administrative division of the High Court, with all the cumbrous formality and cost that may entail compared to a cost-neutral tribunal. Yes.
Just so I understand the submission that
Yes.
you're making. You say that your starting point is that if he's right and these mandatory provisions are not given effect by starting point, setting aside the decision, then there is no sanction for
Yes.
their Yep. Okay.
Yes, exactly. And I rely on the case of Tandy. It's in my skeleton argument. I needn't trouble your lordships, my lady.
Just tell us where.
Yes, of course. If I could first just very quickly give you the case reference in the bundle. So it's tab 12. And it starts at page 174, and the passage I rely on is in fact, I may as well deal with it now, perhaps, having gone there.
Yes.
Page 209, it's very short. Parliament has chosen to impose a statutory duty as opposed to a power, requiring the local authority to do certain things. In my judgment, the court should be slow to downgrade such duties into what are, in effect, mere discretions over which the court would have very little real control. Now, that, in my submission, is precisely the risk here. Because if it's not practical for a decision of this nature to be heard by the administrative division of the High Court, and the First-tier Tribunal is unable essentially to say, well, a decision in breach of these rules is wrong and invalid, then the practical consequence is nobody is policing these rules. The regulation is deprived of its teeth, as it were. The other point in connection with that is that the consequences of non-compliance with Regulation 31 are, in my submission, significant. It is not sufficient simply to say, oh, well, you can go and have an appeal and that can be determined. That there is inherent prejudice in the spectre of a ceasing decision being raised by a local authority, which may cause real attendant anxiety and distress with parents some of whom have significantly disabled children. There is also the prejudice of actually having to go through the appeal process, which might otherwise be unnecessary. And the difficulty is compounded when one considers that the judgment of the local authority will have been exercised without any involvement of the parents, the teacher, and so on, as to what the child's needs actually are and what the consequences might be. And so when the question is asked whether Parliament considered total invalidity, and one has to look at the consequences of the breach, we say that the consequences of the breach are significant, or potentially significant. And I propose to move to ground 2, with your leave, my lord.
Yes.
I'm grateful. In outline, our core submission under this ground is that the Upper Tribunal was correct to construe the phrase "in the local authority's area" as denoting a test of ordinary residence rather than presence. I must confess that I am still slightly unsure as to the test which is being advocated by the appellant, which is described as one which is more a presence approach in the skeleton argument. In my submission, a test of ordinary residence is concordant with the statutory and context and purpose, and a test of presence would give rise to unpalatable consequences and practical difficulties which are not consistent with the purpose and context of the statutory regime. I propose to develop that submission in the following way. First, I will take the court to the legislation very quickly. And then I propose to deal with the context and deal with the case of JG and also the case of Stuart and the consequences of an ordinary residence test. And then thirdly, I will address some problems, practical and otherwise, with the presence test. So if I can, I don't think I need to take you, my lady, my lords, to section 24, given it is simplicity itself in some ways. Except I make this point, the language is general. I accept it doesn't say the test is ordinary residence, but it doesn't say it's presence either. The only real textual context within the Act itself in my submission is section 83.6, which my lord referred to as
partly in Wales.
Yes, the Welsh provision. I must make clear the provision was enacted by the Westminster Parliament, not the Senedd. There is a bit in square brackets, and I'll just take you to it, which was enacted by the Senedd, but that is not material for our purposes of my submission. So it's behind tab 3 of the authorities bundle, and it's page 39. And it's subsection 6, a reference to a child who is in the area of a local authority in England does not include a child or young person who is wholly or mainly resident in the area or local authority in Wales. Now, I rely on this because in my submission it introduces two important concepts. The concept of absence. If someone is mainly resident, it means they're not always resident. And the concept of residence, which is the language used by the subsection. Now, it might be that my reliance on those propositions is perhaps OTOs after this morning, because I think it's accepted, well, I understood it to be accepted by the appellants that a short-term absence or some absence is permitted by section 24.
We got about as far as a term in Dubai.
We got to a term in Dubai, precisely. And I will have more to say about Dubai when we come to
Mr. Lyons started
ground
cavilling once we got to a term in Dubai.
Yes. Now, I do just pause here to say that this, we submit, is a relevant and informative textual context to Section 24. We are not saying, and we're not asking the court to have regard to the special educational needs regime that exists in Wales. That the fact that it's different, in my submission, has no bearing on what is said here, which purely delineates responsibility. It's not involved with the type or method of provision that is provided. So turning then to context, in my submission, ordinary residence is consistent with the purpose and context of the Act. The aim of Part 3 of the Act is to provide special educational needs provision and to do so with continuity and consistency. We are not concerned here, with respect to my learned friend's arguments, with the sort of potentially short-term duties that arise under other legislation under which local authorities have a duty to provide support and assistance, for example, the Housing Acts or indeed the parts of the Children Act. We are concerned with a provision that is aimed at developing children and ensuring that their developmental needs are met when they are children in particular. And that requires a focus on continuity. And we submit that the Act has that focus on continuity. And we have discussed about the term in Dubai, but there are other circumstances where children are commonly absent from a local authority's area. For example, children who go to school in a local authority area other than the one in which they live. Now, contrary to what my learned friend says, I submit that this is not vanishingly rare. And this will be particularly common in urban areas where there are many smaller geographical local authorities. For example, a child could live in Islington and go to school in Camden, 10 minutes away. But also in the circumstances where children with more significant needs may be put in residential placements, for example. And they may well be outside the local authority area in which they live. It's also relevant for children who have separated parents, for example, where the parents have joint custody of the child. They might live separately, they might live in separate local authorities, and the child may spend 50% or roughly 50% of their time with their mother and 50% with their father, or 40% with their father. The child in those circumstances will be absent for half the time from the local authority's area. So it would make absolutely no sense in my submission to say that there was a presence test denoted by Section 24. It just wouldn't fit within the statutory scheme of the Act and the purpose of providing education over a longer period.
Do you say that, for present purposes, a child can only be in one area at any given time?
I say that a child can only be present in one area at any given time, yes. A child, as I shall come on to in just a moment, if I may, my lord, because this is an important point, may be ordinarily resident in more than one area, but that is no bar to the construction I'm advocating. But I will come on to that. I just, first of all, before I do, want to deal with the case of Stuart. So Stuart is at tab 13, page 211. The appellants rely on this case because Section 17(1) of the Children Act 1989 in this case was interpreted as meaning, or having a meaning that was based on presence, so that children had to be present in the area of a local authority for the Section 17 duty to be triggered. And the case concerned a woman and her children who had been living in Hammersmith. Hammersmith said they made themselves intentionally homeless. and they were accommodated by Hammersmith in a hostel in Lambeth. And the children went to school in Wandsworth. And so there was an argument as to which local authority had the duty under section 17(1) to provide, to safeguard and promote the welfare of children in that area. I defer entirely to my lady's experience in this area. It's my understanding that this is a general duty. It's not based on a needs assessment. It can include urgent and short-term assistance, for example, the provision of accommodation temporarily, cash or other services in kind. In my submission, we are dealing with something, therefore, that is very distinct and different from the Children and Families Act 2014. What was decided in this case is set out materially for our purposes at page 218. And at paragraph 28. The rival submissions, perhaps curiously, were that on the one hand, the definition should be geographical area, and in the other, in the local authority's area, meant in the local authority's remit. And the court, perhaps unsurprisingly, determined it did not mean remit, it meant geographical area and required presence. And at paragraph 28, in fact, could I just trouble the court to read paragraph 28? In my submission, the crucial points being made here are that, first of all, this is a general duty, not based on a needs assessment. That is unlike the Children and Families Act. Secondly, under this duty, more than one local authority can have the duty triggered at any one time. So, for example, in the case of the child who lived in Lambeth, went to school in Wandsworth, both Lambeth and Wandsworth were subject to this duty. Again, entirely different to the regime in section in the Children and Families Act 2014, where only one local authority at any time can be charged with the duty. And so in my submission, I say, far from this supporting a presence test here, this shows exactly why a presence test would not be suitable for this statutory regime.
Section 30, that's of the Children Act. What is that? Mr. Beatson said, the absence of a dispute resolution procedure such as that in section 30 in respect to the ordinary residence of a child supports the view that a section 17 duty may lie on more than one authority.
That sounds like the Children Act.
Yes, so as I understand it, my lord, what was the situation that pertained here was that Parliament had amended the Children's Act in respect of two sections to include a definition of ordinary residence in those sections, but had not done so for section 17.
Okay. And the proposition that a child can be physically present at one home during the week and another at the weekend doesn't require
No.
a reported case, to say. But,
No, but yet is an argument made against me. And that's why I think it's important for the court to understand the full context of Stuart.
You call the case Stuart. It's called S. They lived in Stuart Road, but it's not otherwise a named case.
Yes. Yes, I think it's cited as Stuart in the appellant's skeleton. So I defer to Mr. Lyne on the full name.
Not to worry.
Can I turn then to ordinary residence? Because we submit this is the correct test and the crux. Yes. And I wish to deal with the principal objection to ordinary residence that was raised in JG and which my learned friend relies on. And that is that you can be ordinarily resident in two places. I accept that a child can be ordinarily resident in more than one place. A paradigm example might be, as I say, when the child lives with separated parents throughout the course of a week, spending half the time with one parent, half the time with the other. But in my submission, that won't be terribly usual. The fact that a person is ordinarily resident in more than one place does not, in my submission, logically mean that two local authorities must necessarily be charged with the duties under the Children and Families Act. And there are two reasons for that. The first reason is that the fact a person has a right to seek provision from only one provider of services does not mean that by being ordinarily resident in two places, they're entitled to two lots of the service. All it means is that person may exercise a choice about in which area they seek the service or the provision. I accept the example that I'm about to give is not on all fours, but it's instructive nevertheless. You know, an example that comes immediately to mind would be voting in a parliamentary election. One can be ordinarily resident in two constituencies and decide in which to register to vote. It does not mean one can vote twice, of course. Now, that's not on all fours with the current situation, I accept. But the point is, just because you're resident in two places doesn't mean you have the opportunity to have two lots of the same service if you've only got a right to it once. The second reason is that the Children and Families Act itself contains mechanisms to stop a person who is ordinarily resident in two places from obtaining two parallel EHC plans from two different authorities. The gateway to the provision of SEN services is not simply whether you're in the local authority's area. That is, it's not simply responsibility, it's also necessity. A needs assessment is the first step that must be undertaken in order to obtain SEN provision under a plan. And local authorities must conduct needs assessments only if it may be necessary for special educational needs provision to be made for the child under a plan. And equally, the provision, SEN provision itself, will be made under the needs assessment only if it is necessary to do so.
Which section supports that?
Can I take you first to so tab 3, page 14, which is section 36. To subsection 3. When a request is made to local authority, the authority must determine whether it may be necessary for special educational provision to be made for the child or the young person in accordance with a plan. And then over the page it's 8. The local authority must secure an EHCC needs assessment for the child or young person if having regard to the views expressed and other opinions, it is the opinion of the local authority that it may be necessary for special educational provision to be made for the child or young person. And then the next provision, my lords, my lady, as over the page at page 17, section 37(1). In light of a needs assessment, it is necessary for special educational provision to be made for a child or young person. The local authority must secure it and must maintain it. And so, in my submission, if a child was ordinarily resident in Hampshire, and also sometimes, or perhaps that's not a good example, perhaps ordinarily resident in Islington, and sometimes resident, or also ordinarily resident in Camden, and Islington was notified of their existence, and Islington had carried out a needs assessment and decided to put a plan in place, it would plainly not be necessary for Camden then to secure an assessment and for Camden to put in place.
And that was expressly said by Mr. Beatson.
Forgive me.
That was expressly said by Mr. Beatson in the case
Yes.
you chose to. So the two councils are involved, but only one of them has to do the needs assessment.
And,
Yes.
And in the Cornwall case that we looked at, or I was going to go and do my homework at the short adjournment, which I have indeed done, you'll be pleased to hear, that was a case where there were three local authorities squabbling about who was going to take the responsibility for it was residential care in that case. And their lordships, Supreme Court 2015, and their lordships went back and reinvented the wheel. That's their job, isn't it? And did a whole tranche on ordinary residents. But interestingly, it says at paragraph 36, it's common ground that in the present context, that's to say squabbling local authorities about who's going to do the assessment and pick up the bill, unlike others considered in the authorities, the subject can be ordinarily resident in the area of only one local authority. Otherwise, the test would not be an effective tool for allocating responsibility for services or their costs. So I haven't had an opportunity of obviously going over the authority with a fine-tooth comb, but I just thought that you might both find that of interest.
Absolutely, my lady.
Because it's a complete recognition by the Supreme Court, no less, that you can have more than one. But actually, when you're trying to decide who's going to have take on the caring responsibilities of a person with considerable needs, then it has to be logically and practically it has to be only one local authority.
That conclusion by the Supreme Court would undermine the ratio of JG about the interpretation of Section 24, which is based predominantly, in fact, perhaps it's good to turn to JG again now.
Yes.
It's based predominantly on the fact that somebody can be ordinarily resident in two places. Even without that authority from the Supreme Court, for the reasons that I've said, even if it were possible, perhaps in circumstances that weren't considered by the Supreme Court to be ordinarily resident in two places, for the reasons I've set out with the mechanisms in the Act, that also undermines the logic set out in JG. So JG is behind tab 19. My lords, my ladies. And the material part of the judgment is at page 374.
Is Cornwall being referred to in the list?
Yes, it is at paragraph 134.
Sorry, what page?
So it's page 374, my lady. And Cornwall is referred to in paragraph 134.
Yes, that's where I got the.
Yes.
That's why I wanted to read that because
Absolutely, my lady. Of course, Cornwall was not looking at exactly the same statutory
Understood.
scheme. These passages, particularly 134, are a mainstay of the appellant's submissions to this court, just as they were a mainstay of their submissions below, and they were dealt with extensively by Upper Tribunal Judge West below. And
Just looking at
yes,
this. Mr. Justice Nicol quotes Cornwall,
Yeah.
paragraph 42. But paragraph 42 follows on a discussion of a House of Lords case, Barnett ex parte Nilesh Shah, about whether 4 foreign students qualified for an education grant on the basis they'd been ordinarily resident in the UK throughout the 3 years preceding the first year of their course. And it appears that it was held that they could be ordinarily resident here or abroad at various points during the 3 years. That doesn't seem to me to help much by comparison with a rather clear, unqualified statement of Lord Carnwath at paragraph 36 that in the context of local authority responsibility for a child with physical and learning disabilities, the subject can be ordinarily resident in the area of only one. It's fair to point out that that was said to be common ground between councils, but still, these are quite deep waters.
deep, and I do not propose to launch myself into them in
Yes.
opposition to them. Could I ask your lordships, my lady, to look at paragraph 134 on page 374, JG?
Of Cornwall.
JG.
Oh, JG. Yeah.
I'm grateful. To the extent that this decision conflicts with the Upper Tribunal's interpretation of Section 24, I submit that the Upper Tribunal's decision is to be preferred. It is important to understand, and one can see this at paragraph 128 on the first line, that the dispute here, obviously it concerned the moving regulations, which use similar language in the local authorities area. But the dispute between the parties, or between council, was whether or not a residence test applied or an ordinary residence test. It wasn't a dispute as to whether the test was presence or ordinary residence. The main basis of Mr. Justice Nicol's decision at 134 appears to be that you can be ordinarily resident in 2 places, but you can only have one local authority under the Children and Families Act charged with the duty providing provision to a child. In my respectful submission, that cannot, as a matter of logic, be sustained. I have set out how the Act itself would not require 2 local authorities to be responsible for providing special educational needs provision or securing an assessment, even if it were possible for a person to be ordinarily resident in 2 places.
But it can work, can't it? Because Mr. Justice Nichols says there can part you've just read out, there can only be one local authority responsible for a child's special educational needs, whereas a person may have an ordinary residence in more than one place. And that's been confirmed, isn't it, by the Supremes? Because basically you could be ordinarily resident in one place, but only one local authority is going to pick up the bill.
Yes.
And that's why we have contested issues and hearings about who's going to be the designated local authority.
Precisely. So the fact...
So actually that does work, but it doesn't matter that the child in question might be ordinarily resident in two places. It doesn't stop only one local authority having to pick up the responsibility.
That's precisely right, my lady. And so that is why we say that the submission that ordinary residence cannot be the test, based on the fact you can... No. It doesn't work in my submission as a matter of logic.
No, I mean, have ordinary residence in two, and then battle ensues. Which one of the two is going to be the one that picks up the bill?
And of course...
But you're not going to have a third local authority where they are not ordinary residents, which does sometimes happen.
Yes.
I've done a number of designated local authorities where the argument has turned on ordinary residents in one of, say, three local authorities.
Yes.
And the one that you decide hasn't got ordinary residents, gets the get out of jail free card.
Yes. My lady, in that case, can I move to the last area of my submissions on ground 2? My lady, my lords, we submit that the test of presence, for which the appellants contend, has a number of significant difficulties in practice. First of all, it's not clear in my submission on the appellant's arguments as to what type or nature or duration of presence would be necessary.
Sorry, what type?
Type or nature
of
or duration of presence would be necessary or sufficient for a person to fall within the responsibility in section 24. Now, the appellants in my submission try to get round that by saying, well, this is really just, it's a matter for the local authority to decide whether a person is in their area or not, and it's a factual question that can only be disturbed on irrationality grounds by judicial review. That, in my submission, it cannot be right. First of all, it conflicts somewhat with the appellant's submissions on ground 1, because they also say that the First-tier Tribunal cannot approach questions with a judicial review lens, looking to rationality and so forth. If that is so, then it would mean that the First-tier Tribunal couldn't properly adjudicate on a ceasing decision made under section 45(1)(a). The next problem that arises is that JG is not authority for the proposition that a presence test can only be challenged on irrationality grounds. That it was in that case is because the case was a judicial review case. And in my submission, that this sort of amorphous test of presence, which is just left up to the local authority to decide, is not concordant with the statutory intentions and the context. It provides no certainty to children and their parents as to which local authority has responsibility for them. But more to the point, it provides no measure to the First-tier Tribunal to decide whether a person is in the local authority's area or not. By contrast, we say ordinary residence is an established test. It's established by the Supreme Court in AAA. The factors that go to it are clear.
So that submission is that there are no criteria for testing the proposition of physical presence.
Which in practice...
It goes beyond that, doesn't it? Because Mr. Lyne was forced to say it means more than physical presence. The fact that you're within an area physically does not mean that the local authority owes you a duty.
Yes.
And
we say that's not a workable test. There needs to be some certainty there needs to be certainty for children and their parents. And there needs to be certainty because when an appeal is brought against a decision falling under section 45, 1A, a central question for the tribunal will be looking at the local authority's judgment whether a person is in the local authority's area. And if that's simply a question for the local authority to determine, we get into a logical loop. It's circular logic. Because it would mean what the local authority says it means, and then it couldn't possibly be challenged effectively. And the tribunal couldn't exercise, I'm not going to launch back into ground one, but the tribunal couldn't exercise its adjudication as to whether it was right in fact, law and judgment. There is a particular difficulty in the application of a presence test, however, in the case of looked after children. We set this out at paragraph 51, and the court's already been taken to our example as an argument in the case of looked after children. It is worth noting, I appreciate this is only of perhaps slight persuasive authority, but the guidance from the Department for Education and its predecessors has been consistent over many years that the test is one of ordinary residence. And if I may, I'd just like to take you to the Children in Care Guidance, which was promulgated under the antecedent legislation, which had similar wording for responsibility. That's behind tab 28 and page 646. And it's the guidance on looked after children with SEN based out of authority. And if I could ask your lordships, your ladyship, to turn to page 649. This gives guidance on section 321(3) of the antecedent legislation. And at the last paragraph on that page...
What's the date of this, by the way?
I believe... I will have to double check that, my lord.
2009.
2009. So before the advent of the Children and Families Act. But the department's view was the term in their area is not defined in the legislation. In line with established practice, the department construes this phrase to mean ordinarily resident in their area. I simply raise this now because this morning your lordships and your ladyship were taken to the code, which also set out an understanding that the relevant concept was ordinary residence. In my submission, that is a test which sits far more comfortably with the context of the Act. And in the context of children in care, it provides protection and continuity so that children don't fall into gaps in provision. I accept that at best, a child who is in short-term placements can have a plan transferred. But there is still prejudice there because it relies on the transferal or the transfer of a plan which may be administratively time-consuming. We know, unfortunately, that local authorities aren't always able to meet the timescale set out in the regulations. But it would also mean that a local authority could, if it wished, cease to maintain a plan. And that cannot possibly, in my submission, have been the intention of Parliament when drafting Section 24. By contrast, we say the problem doesn't arise if it's ordinary residence because there are short-term foster placements, then the child's still ordinary resident in the local authority that looks after them. And that authority can maintain the plan. It doesn't mean that a school in that local authority necessarily has to implement it. It might be that the provisions actually provided outside of the authority, but it's the authority that retains control and responsibility for the child's needs and meeting them. The next problem is... yes,
are we entitled to rely on the fact that this was the department's view in 2009? Do you say that in using the phrase in the area or in their area in 2014, Parliament should be taken to have had in mind that that was the departmental view in 2009, or is it irrelevant?
It is not my primary submission, and it's not what I primarily base the construction on, no. But I would note that the current statutory code made under the 2014 Act also refers to ordinary residents, and we were taking to that this morning. And so I simply take your ladyship to this to demonstrate that it is plain that a test of ordinary residence is perceived to sit comfortably in section 24 and indeed solves a lot of the problems that are being asserted in this guidance. And the same is true in respect of children in military families. And that's the final problem that I raise and submit that is caused, that a test of presence causes difficulties. The instant cases, of course, are a prime example of the difficulties caused. But it is notable that members of the armed forces are deployed to different theatres abroad, also in the United Kingdom. And where those servicemen and women have a home in a local authority to which they intend to return, and the Navy, for example, recognises that that's where they live and pays for them to go back and visit, and pays for them to go and live there immediately after their deployments ended early. It is plain in my submission that an ordinary residence test gives this class of people and their children the protection that the Act envisages. It would be unconscionable, in my submission, for a construction of a section which is designed to assist vulnerable children was interpreted in such a way as the people in this country who are sacrificing sometimes the most for this country are disadvantaged precisely because of that sacrifice. It is suggested at one part of my learned friend's skeleton argument that the father in this case unilaterally went to Dubai.
I think there's not very members of the military would regard their posting as being a unilateral decision.
It was important, and it was an order from His Majesty's Royal Navy. And the duty to consult did not lie on the father or the Navy, it lay on the local authority. Now, a presence test would mean that a child in those circumstances returns to the UK and there isn't a plan in place. And that is precisely what almost happens here. That creates inherent disadvantage. It is no answer in my submission to say that steps can be put in place to make the return easier to the UK, as the local authority offered here. The fact that, and they are referred to as mitigating steps, the fact that mitigation has to be put in place at all simply reveals the disadvantage caused by the construction. Because if the disadvantage didn't arise, then the mitigation wouldn't be necessary. Further, they were discretionary steps. It is commendable, and I would say vital, that this particular local authority, home as it is to the Army, the Navy and the Air Force, would want to put in place those steps. But they cannot be guaranteed. And they may not be offered by another local authority. And so this presence test would leave an important gap whereby the children of service families are put at a disadvantage because of their parents' service to the nation. By contrast, an ordinary residence test does not give rise to the problem. As here, it was plain that the family was ordinarily resident in Hampshire. It's where they'd always lived. It's where their family lived. They retained a home in Hampshire. It was clear they were ordinarily resident in Hampshire and they were going to return. My lady raised the prospect of a family who said, well, we're just going to Australia to try our luck. That, of course, is completely different circumstances entirely. We're dealing here with classes of children who are, in the case of looked after children, on the margins of society anyway. And it is no excuse or no argument in my submission to simply say, well, it'll be a minority of cases, so we don't need to focus on that. This legislation deals with vulnerable people, whether or not they are in exceptional or unusual circumstances, and it must be applied in a way that, in my submission, has the broadest application to get as many children who need that assistance within the scope of that assistance. And that is why we submit that an ordinary residence test is not only preferred, but is the natural construction of Section 24.
Can I ask the question I
Yes.
flagged up this morning that I was going to ask you? Suppose that T's family had said to Hampshire, we've arrived in Dubai, the Navy is not prepared to pay for T to go to school in Dubai, so you've got. Would Hampshire have been obliged to?
So I was going to deal with this question under ground 3, but as I finished ground 2, so this is perfect, but it may anticipate all my submissions in ground 3, so I think it's a very useful place to start, my lord, if I may respectfully say so. Perhaps I can explain it and approach it like this. There are different classes of people with different types of absence, which perhaps are relevant to your lordship's question and your lordship's illustrative example. One class of children will be those that we can say fall, for argument's sake, within Section 42.5. There's suitable alternative provision. We don't need to worry about them in my submission for the time being, for the purposes of this argument. There will be another group of people, let's say, where there's no suitable alternative provision. And the following propositions are relevant. First, the fact that one cannot secure SEM provision, a local authority can't secure SEM provision, is not a ground on which a decision to cease to maintain may be made. So the fact one can't secure the provision doesn't mean one can cease to maintain
The plan.
the plan. The duty in my submission is to provide suitable provision. If a school has been named in a plan, the local authority has in essence provided suitable provision. It has a school named, a place open. The fact that a person decides not to send their children to that suitable provision does not mean in my submission that the local authority is in breach of duty. The local authority has provided suitable provision. The parents have decided not to take them up on it. The local authority can review and amend a plan at any time. And they can amend the name of the school to remove a named school, and therefore free up the place, and instead replace it with a type of school. That, in my submission, would be an obvious solution in the example that my Lord raised this morning. There isn't suitable provision. Will a local authority be in breach of duty by not securing the provision or providing the provision? No, in my submission. Because it can amend the plan, it can say, okay, while you're in Dubai, you know, we name a type of school, we freed up the school place that you would have gone to if you were in England. On your return to England, either the plan will set out on your current needs, this will be the type of school, or it will be this named school if the local authority wants to plan in that way.
So the answer to the question, would they have to pay for a school in Dubai?
Is no.
Is no.
It would also, as a backstop, be perfectly possible, in my submission, for a local authority to reassess the needs and say, well, given that you are abroad, outside of the jurisdiction, it's not necessary to meet your needs in England, especially if your needs are being met in Dubai, for example. So there are various mechanisms in my submission under the Act. The Act allows for various circumstances whereby the local authority isn't going to be in breach of duty. And in my submission, the argument that the local authority is necessarily going to be in breach of duty just isn't right.
They can reassess needs,
Yes.
but they can't on facts such as the present, where
Yes.
there's an intention to return. You
Yes.
say they can't cease to maintain the plan.
No.
It's the contents of the plan.
Yes. So it's the provision.
And can that be expressed in a way so that if and when the child comes back, you can flick the
Yes.
switch?
Yes, and indeed, much is made of the fact that there will be a review on the child's return anyway, and of course that will be an important part of meeting the child's needs. It doesn't mean, of course, the local authority has to wait for the child's return to conduct a review. It can conduct a review at any time. We say that the answer to ground 3 is straightforward, and I think I have probably covered the majority of my submissions, and perhaps we'll finish slightly sooner than anticipated. I do just, though, want to deal with, before I finish, the facts as they pertain to this case, and
Yes.
section 42.5 and the question of suitable alternative provision. Our submission is this, that there was suitable alternative provision in this case. It was the primary school in Dubai that was secured with the help of the Ministry of Defence and facilitated by the Ministry of Defence. It is right, of course, that no determination was made by the local authority that was suitable provision. But in my submission, that doesn't help the local authority. The reason why was because they had not consulted, and that they had, in my submission, for reasons that pertained at the time and an understanding that pertained at the time, closed their ears to the question of provision for this child. Could I start by taking the court to the guidance Education Overseas for Service Children, promulgated by the Ministry of Defence. So that's behind tab 29. It starts at page 661. My lords, my lady, I simply want to take you to 3 paragraphs and 3 sections of this guidance, which sets out the scheme that operates in the armed forces, essentially, that applied in these circumstances. So the first section is at page 662. It's at the bottom of the page. The headline is GCS Schools and Settings. And it simply sets out that the MOD provides schools and early years settings in key locations overseas, and they're run by the Defence Children's Services. The second part of note is on page 664, under the heading Educational Supportability. And what it sets out is that in order to accompany parents on deployment, there needs to be a confirmation of educational supportability. So there needs to be an assessment by the armed forces that they can support a child's needs. And that is done by what is called a MASO assessment, an MOD assessment of supportability overseas. And that is dealt with materially at page, the very top, the very bottom of page 667. The headline is the last line of the page. And then at the top of page 668. And the court will ascertain here the point that if children have special educational needs provision in the United Kingdom, an MOD assessment of supportability overseas would be required. That is what the bullet points set out. And those are assessments which are done in conjunction with multi-agency subject matter experts, which give advice to the Overseas Command about what provision a child will need and whether it's available. Now, in this case, that was done, and there was provision available in the primary school in Dubai. Had the local authority consulted properly or at all, it would presumably have found that out. And it could then have used the obvious mechanism in section 42.5 to absolve it from any qualms about providing provision during the term of the deployment. But the local authority did not consult. It refused to mediate. It did not engage with the claim and instead tried to strike it out in the First-tier Tribunal.
And this was all while they were in Dubai?
Yes, I believe so. This was when they were in Dubai.
I hadn't picked that up. Were there proposals to mediate?
So if I could take you to perhaps it's set out in the judgment of the Upper Tribunal,
Okay.
my lord.
Just, I'll find it.
Yes. There is a mandatory obligation.
There is a...
To mediate. There is a mandatory obligation to enter into mediation.
I've missed it.
Was the tribunal entitled to use the fact that the family did in fact come back to Hampshire to show that the legal argument had been right all along, that it was temporary? I think it's disputed. I think Mr. Lyon and his team say that that's the wisdom of hindsight.
In my submission, that is wrong. This was not a family who was moving to Dubai. This was a family who was being sent temporarily in the service of the nation to Dubai.
Well,
and they
was
were
it being suggested that it was other than temporary?
Certainly not by the parents. And in
No, by the local authority.
No, in my submission, the local authority was suggesting that...
They were saying it could be temporary, but that means that you're
Yes, they were saying-
present and therefore you're out with the scheme.
Precisely, my lady. Yes. It's also said by my learned friend, and this is said at, I don't need to take you to it, but it's said at paragraph 55, page A of his skeleton argument, and Ms. Bouffet's skeleton argument, page A247. It said that consultation would have been limited, in any event, to considering the ceasing question only, and would not have considered the question of suitable alternative provision. In my submission, that's not a sustainable position, and it divides artificially the information that the local authority was likely to obtain. It is, in my submission, fatuous to say that the local authority would not have explored matters associated with and relevant to the deployment, given that the deployment was the precise reason given for not maintaining the plan. And if the local authority is saying that it would have considered or does consider only whether a person is in the local authority area or not, and not questions and matters that are related to that, then in my submission that would be manifestly wrong. And it must be noted, as I have already set out, that this particular local authority is unusually the home of the Army, the Navy and the Air Force, and if any local authority could be expected to understand the importance in consultation of looking at questions of deployment more widely and interaction with the Ministry of Defence and the Overseas Command, it would be this authority in my submission. So it's simply no answer in my submission to say that it wouldn't have considered the question of suitable alternative provision. It must surely have done had it consulted. And the reality in our submission is that very early on, this local authority came to an unshakable conclusion that it was not responsible for this child. That is why it didn't comply with Regulation 31. That is why it refused to mediate. That is why it sought to strike out the claim in the First-tier Tribunal. It was a refusal to engage. And the local authority can't now, with respect, rely on that refusal to suggest that Section 42.5 was of obvious application. I'm just going to turn my back, if I may. Ms. Sawes-Keeley has rightly pointed me to a point that I neglected to make in ground one, and I make it very, very quickly, which is just, if my lords, my lady, one looks at page A216 of the appeal bundle, which is the First-tier Tribunal's decision, one sees that after, behind tab 8.
Which paragraph?
So it's paragraph 26. After the conclusion about Regulation 31, the First-tier Tribunal then does go on to explore the question of Section 45(1), and rightly point out that it's an exercise of discretion, it's not mandatory to cease to maintain a plan, and does engage with the merits of disadvantage caused to this particular child. And I simply raise that because it's not the case that this tribunal simply stopped short of considering the merits and then carrying out its function to decide what should happen in this case. My lords, my lady, those are my submissions, and unless I can say further, I'm grateful.
Thank you very much, Mr. Gilly. Ms. Swords-Keeley.
Thank
you. Right. Mr. Lyne.
Thank you, my lords and my lady. I have momentarily some rearranging to do, so...
Oh yes, that's fine.
Me. I would not have time to address everything that Mr. Gilly has said, even if I wanted to, so that would
no need to repeat anything you said this morning, but
yes, and
do respond if you wish.
So, taking first some points on ground one, if I may, and the reference to the Bromley case and Lord Justice Sedley, which I did refer to in oral submissions, but didn't go to the precise quotation. And if I may do that, it's in the authorities bundle at page 232. This is just to address the point raised about the tribunal's jurisdiction being a general jurisdiction but also supervisory. And you have the quote there, which Mr. Gilly earlier took you to.
Yes.
I just wish to make a comment about the context here. This was a decision, I believe, in the late 90s. It was in 2004. And what I understand to be discussed here by Lord Justice Sedley is a transition away from challenges against local authority decisions concerning statements being within the purview of the High Court on judicial review into the domain of the specialist tribunal. And you can see in the quote it says the new regime, and his lordship goes on to talk about, unlike the High Court, it's a specialist tribunal. So a comparison is being made there between the alternative functions of the High Court as compared to the specialist tribunal. His lordship says, in particular, this is about halfway down, where a court has to limit itself to the interpretation of terms of legal art and the setting of outer limits to the meaning of ordinary words in their statutory context, the tribunal is empowered to take a much closer look at the LEA statement. Indeed, for many purposes, it stands in the LEA's shoes, re-evaluating the available information in order, if necessary, to recast a statement. Then says, but in carrying out this function, it also has a supervisory role. So I just wish to make the point that when there's discussion about the supervisory role, it's not to say that there's a general appellate jurisdiction and a supervisory function. The discussion is about the tribunal's purpose in reviewing, in these times, a statement of special educational needs and recasting it if necessary and standing in the local authority's shoes when doing so. And there is, we say, a distinction between that function and the supervisory role, for example, of the High Court in judicial review.
No, that's much more limited, isn't it?
Precisely.
I thought we were agreed in the course of today that it was you who said that the FTT can look at everything at the time
As at the time of
the decision. Yeah.
Well, my lord, I just wish for some care to be taken over the reliance on the term supervisory jurisdiction and place it in its context. But I see your lordships understand that point. Mr. Gilly said that he doesn't submit that the tribunal can look at any breach. It can only do so when the procedural requirement governs a matter in question. And I understand his reliance on that point to be placed on the statutory language, section 51 of the Children and Families Act. If I can ask your lordships to turn that up, it should be in tab 3 of the Authorities Bundle and at page 33. I simply make the point that based on the language at 1, the right of appeal is against the matters set out in subsection 2. So matters is itself defined by reference to what is set out in subsection 2, and the matters are the decisions. So in my submission that it remains the case that it's the decision that is under appeal and that is the focus of the tribunal's decision. In my submission, it's unclear how it assists the analysis to break that down to a question of whether the procedural requirement goes to a matter or whether it doesn't.
The tribunal can look at the matter in all its aspects. It's an appeal. It's an appeal de novo, or it's a review. It's a de novo appeal, and it can look at the decision in all its aspects. And if there has been a failure to comply with procedural requirements, that's a feature which comes into the consideration of even on your case, it's material. On their case, in this case, it's determinative. But you can't sort of chop off and say it's not part of the decision.
Well, I had understood Mr. Gilly's focus to be saying that certain matters are within its jurisdiction, which are of a procedural
I think that
nature,
is how he puts his case.
and others are not.
I mean, we may not agree with we may not go quite as far as that, but what I understood you to be proposing just now is that the matter is the decision, and we don't look at anything anterior, which is your ground one.
That's the point that we have made in the skeleton argument. I have made the point already, and I understand I'm not to go over what I've said unnecessarily, but to the extent that that is something that's looked at, then the tribunal has to go further and deal with the merits of the decision at the relevant time. It was also said that at one point, if the tribunal's jurisdiction is not, as Mr. Gilly contends, there will be no recourse in relation to, in his words, policing local authority decisions. I simply reiterate that there are other avenues in existence that we discussed earlier this morning, including the LGSCO. So those are my points in relation to ground one.
Yes.
I rely on what was said earlier this morning. Otherwise,
Yes.
Turning to ground two, on the statutory language point, section 24 of the Act, which we've had referred to variously, but it's at page 13 of the bundle. Mr. Gilly makes the point, and he accepts very fairly, that it obviously doesn't use the term ordinary residence, but he also says it doesn't say presence either. But it does say in the authorities area, and so there is a question as to what is meant by the word in, and we say to the extent that a meaning is attributable to that, it more obviously means presence. The S and Wandsworth case was referred to, and in that case, well, I perhaps don't need to turn it up unless there's particular questions, because Mr. Gilly has helpfully already taken your lordships and ladyship to it. But the terminology of section 17 of the Children Act, whilst not identical, and you have it at page 4 of the authorities bundle, is very similar. It uses the term within their area, and the S case considered whether that should be looked at purposefully or literally to mean presence, and the High Court in that case determined the latter. Now, I accept that the statutory context is obviously different, although there may be some relatable features, but what I do say is that that demonstrates that the starting point, and in my submission a very strong starting point, is what the language says and giving it its plain ordinary meaning. There was reference in Mr. Gilly's submissions to guidance from 2009, and that is of course very old guidance, and it predates the 2014 Act, so in my submission it doesn't greatly assist the court in the interpretation of section 24, but to the extent that it is deemed by your lordships and ladyship to be of some relevance, I would also ask that you take into account page 673 of the authorities bundle. This is guidance that was produced after the hearing before the Upper Tribunal, but the parties were invited by Upper Tribunal Judge West to make written submissions on it, and it was produced prior to his decision. And he refers to it in his decision, so it's from 2024. And materially, in particular, at page 676, there is text which refers to moving outside of England. So it's not dealing specifically with the cases of service personnel, but it's relevant to the position being discussed because they are moving overseas. And particularly in the second paragraph, it says that the local authority has discretion whether to cease to maintain. It says there are no, and it says the local authority has the power to maintain the plan at the end of that paragraph.
They've got the discretion only when they're no longer responsible for the child, which begs the question.
Yes.
For example, when a young person moves out of the local authority's area, one could add brackets, whatever that means, and we're about to decide.
It might well be that that's what we're trying to get to the heart of, but there isn't any reference to ordinary or habitual residents. And that is pertinent in the sense that if that was a departmental view, that would have been an obvious opportunity to say so. It does also say that where there is a move outside of the of England, local authorities are best placed to decide what factors they need to consider. Cases must be dealt with on a case by case basis, and it includes relevant factors that can be considered. And in my submission, even if your lordships accept my proposition that ordinary residence is not the test to be written into section 24, but presence is, I submit that a presence, having temporary absence from an area when it genuinely is temporary, isn't inconsistent with that approach. And to my lordship's earlier question about criteria, whilst we are hesitant in this area of discretion, where perhaps we always differ to lay down hard and fast criteria, because we do say that this is an area where local authorities should be able to make discretionary judgments. The guidance here provides 4 bullet points as to factors that may assist your lordships in looking at that particular question.
So in this case, the criteria for the local authority would have been temporary. The move is expected to be temporary, 3 years stroke 2 years, and they intend to return home on their return to England.
I think there a question is to what is in the circumstances temporary, and I don't accept that a 2 or 3 year absence is necessarily temporary, and the length of the absence itself is only but one factor. It may well be that that is a conclusion on one case, but not necessarily on others, and that's why I say that this is an area where local authorities should be able to exercise discretionary judgments, and generally on those questions, that is not going to be a matter for the tribunal unless it's within one of those statutory appeal rights whereby the responsibility question is engaged, section 45(1)(a) being one of those, but that's not going to be generally the case in other types of appeals. My lady, just very briefly, I don't intend to take very much longer, but hopefully you have referred us to the Cornwall case. Doing the best I can to assist on that and what is referred to by Mr. Justice Nicol. He quotes paragraph 42, and on my reading of it, it must be the final sentence of that paragraph that Mr. Justice Nichol was relying on, where, and I'll pause if my lady is still trying to find the paragraph.
No, I've got it,
Thank you. Where it says, nor did it matter, it seems that they might have had other ordinary residences in their country of origins. So that seems to be what he must have been referring to.
I think perhaps he might have read from 33 onwards before he alighted on that sentence.
Well, that I can't assist with, but I do my best to pinpoint what he must have been referring to. But of course, in the case of Kent, that wasn't the only factor he relied upon when deciding not to import ordinary residents into the predecessor to Section 24, but suggesting that in appropriate cases it will provide indirect pointers, and the other was the statutory language in both the legislation and the regulations. The last point I wish to just respond to is on this ground is that Mr. Gilly, in his submissions demonstrating to the court that ordinary residents provide the answer on all occasions, focused on just one issue, which was the question of assessment duties under Section 36. And that presupposes that prior the previous position, regardless of which local authority you're looking at, is that the child or young person hadn't presented as requiring a needs assessment, but that duty is then triggered. But of course, there are other situations where an EHC plan is already in existence. Possibly that's going to be the majority of cases where ordinary residence doesn't necessarily provide the right answer, given that there is only one local authority that can exercise the duties under the Children and Families Act. And of course, it's going to be not for the individual to choose where they want their rights to be given an effect to, or which local authority they want to do that, as Mr. Gilly was suggesting at one stage. Regulation 15 actually leaves it to the local authority, the first local authority, to decide whether to transfer to the next. And one can readily see that disputes will arise on that, even with ordinary residents, which is not very different to the position without it. So we don't accept that ordinary residence necessarily provides a neat solution in all situations. That's all I have to say on ground 2. In relation to ground 3, I wish to just make the point that I think it's fairly said that if the local authority did undertake a review and decided to remove a school placement from section I would have to accept that that is something that is permissible within the statute. A type of placement can be named, so that is something that can occur. Of course, to get to that point, you'd have to have an annual review, and an annual review, generally speaking, isn't just about that. It's about the entirety of the needs and provision, and I do make the point that it's difficult to see how a full annual review could take place when the child is already absent from the country, let alone the area. The other option that Mr. Gilly says would be available is reassessment. I do submit that that's more problematic, because actually, when you look at what a reassessment is, it is a Section 36 needs assessment. So all the things under the regulations, 6, 7, I believe also 8 and 9, apply, which means that educational psychology advice has to be procured, other types of expert evidence has to be procured, social care advice has to be procured. So it is a complete assessment process, and again, it's difficult to see how that could be done effectively when the child's not present in the country, but also in a case where the reason for ceasing to maintain is simply that the person is abroad. There's no suggestion in this case, for example, that the child's needs had changed materially, so it's difficult to see why that would be something which would itself trigger a reassessment process. And my final point is, as to the criticism regarding the failure to consult under Section 45, that would have been directed to the reason for ceasing to maintain, which was the child not being in the area of the local authority. It would not, in my submission, have been the function of that consultation to provide some sort of assessment of the suitability of the alternative arrangements that are relied on. And I reiterate the point that by the time of the cease to maintain decision, the family had already moved. I've been criticised for saying that was unilateral. I did make it very clear in my skeleton argument that we accept that follows necessarily from the nature of the child's father's service. We make no criticism of that, and we understand his position, and I don't wish that to be misconstrued. I simply make the point that it happened, and that is not something the local authority had control over. It's just that point and nothing more. And unless my lords and my lady, I can assist you with any other points that I've not addressed, and then that's all I have to say.
Thank you very much.
Grateful.
Mr. Ryan. Well, thank you all for your submissions. It will come as no surprise that we're not going to give judgment today, of course. We will consider what you've said. If we will send out draft judgment in the usual way, as counsel there, that means draft not for re-argument, for correction of typos, factual errors, wrong dates and so forth. And after that we will hand down in the modern sense the judgment publicly about having it placed on the National Archive until the formal hand down of the judgment. Its contents are confidential to the parties, including obviously T's family and those in the council who need to know. I think that covers everything. Thank you all very much for your high quality oral and written arguments. Thank you.